So what happened is that I left the case in 2007. In 2008, Judge Yaffe ordered me to pay money to the county without any notice to me. I was gone from the state in October of 2007. In January 2008, Judge Yaffe orders me to pay money to the county because I filed the paper 1 day late. The county had filed their papers 60 days late. He did nothing to the county, and he orders me to pay money to the county without any notice to me, without my being present at the hearing. And I came in and I said, Judge, you can't do that because, number one, you're violating the Constitution, but number two, you're getting payments from the county. And now Yaffe had not disclosed at this point.
Your call may be monitored or recorded.
Yaffe had not disclosed that he was getting payments from the county. And the county had not disclosed that they knew that the EIR was illegal. And nor had Epstein disclosed that he knew that it was illegal. I then got Yaffe to admit on the record at a court hearing that he was getting these payments. And then I disqualified Yaffe, and Yaffe refused to leave the case. And then Yaffe ordered me to make the payment, to disclose my assets, to have that order enforced. And I refused to do that. Then Yaffe had a contempt hearing, at which point, in the contempt hearing, I got Yaffe to testify as the first witness. I got him to testify that he was receiving the payments, that he was not disclosing the payments.
I mean, he should instantly, hold on, he should instantly recuse himself. Federal, state law, I mean, all of the precedent says he must recuse himself. He's a witness in the courtroom when he's the judge. I mean, this is insanity.
Truly, it's not only insanity, it violates every Supreme Court precedent. And you have the Supreme Court precedents of In re Murchison that says a judge can't judge his own actions. You have the precedent of Offutt versus the United States that says that a judge can't take a bribe. And
well, that's like the Secretary of State in Kentucky with the State Ethics Board ruling he can run his own election against Rand Paul for Senate in Kentucky, never before done, and so he runs his own election.
Yeah. I mean, it is total insanity. I mean, this judge is ending up taking a bribe, and then he's judging his own actions of taking the bribe. And every U.S. Supreme Court precedent is against that. So, anyway, so the end result of it is that Yaffe holds me in contempt for not answering, saying that I have to, holds me in contempt and throws me in jail under coercive confinement, saying that I have to stay in jail until I tell what my assets are so that they can enforce this false judgment against me to go out and take my assets.
So now, via a civil judgment, no jury, no nothing, you're in jail more than a year. This is a dangerous precedent if it's allowed to stand. And we know the Supreme Court earlier in the year, you've had some of the other justices refuse it, but now Ginsburg is accepting it.
I'm sorry, you got blocked out. You said the Supreme Court earlier in the year?
Well, I've read over the case, but tell me if I'm right. Wasn't it Justice Stevens, or which one is it that early?
Justice Kennedy earlier in the year denied my application, and then I went to Justice Ginsburg. And Justice Ginsburg was the one.
Your call may be monitored or recorded.
All right, so tell us what's going to
go into the conference.
Sure. So we're running out of time. So tell us, Mr. Funk, the show's almost over here, and we appreciate you joining us from prison, from your political dungeon. So what's happened in jail? I mean, if the Supreme Court says no, I guess you'll live out the rest of the 10, 15, 20 years there, and the taxpayers will pay for it, and a new precedent's set. Judges can say, put Alex in jail. Just put Bob in jail. Put Carol in jail. Just put the Pope in jail. Put anybody in jail. Just dungeons. Just goodbye. I mean, do we do whatever we want?
That could be the case. So it's really up to the Supreme Court to follow their precedents and basically set me free. That's where we're sitting at. Now, one of the things I do want to mention before we close out is that there's going to be a rally for me on Tuesday, the 20th of April, at the L.A. County Courthouse, which is at 111 North Hill Street in Los Angeles, and it's going to start at 7:30 12:30 in the morning when the judges come in to park their cars, and it's going to be continuing until 12:30, and there'll be speeches and things about 11 o'clock in the morning.
And there's also one coming up at the Supreme Court, and we went over that 2 hours ago when we had Leslie Dutton on, and people can find out all the details at fulldisclosure.net. But, sir, in the video interview I've seen, I mean, go back over. This is why we went to war against the British in 1775-76. It's in the Declaration of Independence as the list of abuses, the exact same stuff that's being done to you. Talk about how, I mean, as a lawyer, as a former federal investigator, what this is like for people that don't understand the law.
Well, I'm sorry, they broke you off right after the word talk. Give it to me again.
Well, you talked about the parallels between this and the Declaration of Independence and how big a deal this is.
Well, the big deal is that it's the exact parallel, because when you go to the last part of the Declaration of Independence and you read that last part, that talks about the fact that the king controlled all the judges in the court. And therefore, there was absolutely no way that anyone in the colonies had any opportunity to get any fairness in the judicial system in England. And that was one of the reasons why we went to war. That is why we had a revolution. And this right now is our new revolution, except for we don't have to use guns at this point in time. We are using the democratic process. And by using the democratic process, we are coming through, and we are going to go in, and as I'm doing, I am using the court system because I have a basic...
Your call may be monitored or recorded.
I have a basic belief that the United States Supreme Court is going to uphold all of the precedents. And these precedents that a judge can't judge his own action go all the way back to the 16th century. Started out in common law.
So what are you expecting to do with Baca, the sheriff, these judges, if the Supreme Court tells them to let you out of jail? Are they going to go in there and claim that you've committed suicide or something? You're not planning to commit suicide, are you?
No, I don't think so. I think I've survived, actually, I survived 10 years of this abuse. These judges started this whole thing out way back in 1999, trying to economically break me. As a friend of mine said, if they had the ability to shoot me, they probably would have, but they don't. Luckily, they don't think in those terms. They probably think in those terms, but probably don't have the guts to execute it. Thank God for me. But basically, what my plan is a very simple thing, and I call it the 3 A's. It's awareness, attachment, and action. And it means it's due to people like yourself. People become aware of what is happening. And then they attach to what is happening by keeping up with that awareness. And the third thing becomes action. And as I said in my video, you vote the bums out. Because what takes place is that we are the ones that actually have the ability to do things.
Richard Fine. We got a break. Final segment after this break. Stay with us. We'll come back with some final comments from you. You may